everyone, this is Sachin Sawant, your UK immigration lawyer. Today I am going to talk about, are visitors allowed to work in the UK? So this is I've seen this on many of these TikTok videos and several channels where some automated AI generated videos are made and where people are saying from the 7th December changes to the visitor rules. Yes, they have been changed, some things have been changed, and where the videos state that you can work in the UK, etc., etc. So I wanted to bust that myth, taking immigration rules also and explaining it from that perspective. So firstly, I'll just reference to the rules and I will also show you on screen. Where is that? This one. Okay. So this is the first caveat that they have on the immigration rules. You can see on screen, prohibited activities and payment requirements for visitors. The visitor must not intend to work in the UK. So by default, visitors are not allowed to work in the UK. Everyone needs to understand this very well. I know those videos are talking suddenly there have been changes, visitors can come and work and all of that. Some exceptions have been made, but it's not working per se. This restriction has always been there, it is always there. I will come to the changes paragraph also. Firstly, let me get through this one. So taking employment in the UK, the visitor must not work in the UK, which includes taking employment in the UK. You cannot be salaried employed in the UK. You cannot be working in the UK. The second one it says is doing work for an organization or business. You cannot do work establishing or running a business as a self-employed person. This is another problem that individuals have. They do start their businesses, register companies. I know HMRC doesn't check and all of that, but yes, you are not allowed to be self-employed also. Being on a visitor visa, working, doing a work placement or internship. You're not even allowed to do an internship, which is free working with anyone, any company. You're not allowed that. There are different categories of visas for that, tier 5, government authorized exchange and all of those. Direct selling to the public, you cannot sell goods to the public. However, you are doing it digitally, physically, however, whatever is the mode, providing goods or services. So this is by default the position in the immigration rules. All of these is not allowed. Now I will go to what is allowed. So let us go forward. Permitted activities must not amount. So there is some permitted activities that can be done, which amounts, so it should not amount to replacing someone. So permitted activities mainly means you can do up to a certain extent. You may be attending meetings, training, something like that. I will get into that slowly. The paragraphs will give you some examples. But you should not be filling a role for an employee in the UK. So that job can be done by someone who is a UK resident, settled person, British or someone who can do this job. You cannot fill that role, number one. Providing short-term cover for a role. For example, an individual goes on maternity leave for say a year, you cannot take up the job and do the job for that person. That is also not allowed. I know companies consider this many times, but that is also not allowed. Temporary filling of the role for a UK organization, and where the visitor is already paid and employed outside the UK. So usually if businesses are sending visitors for business visit for whatever reasons, attending meetings, trainings, anything, they should continue to be paid outside UK wherever they are paid and employed outside UK. So they should be employed over there only. They must remain to do so. So it clearly says over here in the rules where in this part where the visitor is already paid and employed outside the UK, they must remain so. Okay. Now the next part, I'll scroll and take up, the visitor must not receive payment. This is very, very important. This is kind of conclusive evidence that they can find against the visitor. Visitor must not receive payment from a UK source, UK company, UK individual, whatever that is, for any activities undertaken in the UK, except, so these are the only exceptions. One is reasonable expenses to cover. So I'll just show you the rules. So they must not receive any other payment except the following: reasonable expenses to cover the cost of their travel. Let's say your traveling ticket, subsistence, basic allowance for every day or something like that, maybe hotel booking or something, including fees for directors if directors are attending meetings, international drivers, a small area, so that also. So or seafarers undertaking activities permitted. So they are bringing in goods and all. It's usually for EU countries where you have land borders and all of that, where drivers coming through. Prize money, yes, that is fine. Billing a client. So except for the following, the client can be billed for their time of work in the UK. So this is usually for IT companies or some other companies, whatever. If you are sending your individual to fix something, do something, maybe train on a particular machinery to be used or anything like that, or software to be used, billing a client for their time, where the visitor's overseas employer is contracted to provide services. So this is very common with IT companies, where they have contracted with some company in the UK to provide a specific service. They send their employee from outside UK to the UK to provide that service. Yes, that billing can be done, but not by the individual, by the company which is outside the UK. And the majority of the contract work is carried overseas. This is very important. Payment must be lower than the amount of the visitor's salary. So whatever is the visitor's salary, let's say it is £1,000 outside the UK, that payment of those services should not be over £1,000. Let's say the frequency is 1 month, the person stays for 1 month. I'm taking ceteris paribus, everything remaining constant. If it's for the same term, if the employee is paid 1,000, it cannot be more than that 1,000. It has to be under that. Payment must be lower than the amount of the visitor's salary. Multinational companies, for administrative reasons, handle payment of the employees' salaries from the UK. Yeah, that is done sometimes. Many times multinational companies do that. Those payments are fine. Paid performances at permitted festivals, that is allowed. Permitted paid engagements is allowed. So in summary, by looking at these permitted paid activities, which are very restrictive, and the previous discussion where must not intend to work, take employment, self-employment, all of that, overall the rules are still the same, and visitors are not allowed to work in the UK. I will further go into the immigration rules where the changes have been made. Let me find that one. Working eligibility, 6 months. Yeah, so should come towards the end. Not this one. Yeah, these are the new areas that have been added. So I'll just explain that. Additional eligibility for visitors coming for permitted paid engagements. When the applicant is seeking to come to the UK to undertake permitted paid engagement, they must intend to do one or more of the following, which must be arranged before the date of application. So this is the thing that has been changed. I remember from the December 7 changes. Yeah, December 7, 2023. This is one of the changes where if you are coming for a permitted paid engagement, it has to be already arranged beforehand, before coming to the UK. It's not that the visitor comes in the UK and then you decide, oh, I want to do this engagement. That's not allowed, which must be arranged before the applicant travels to the UK and declares as part of the application for entry, clearance or permission. So if your visa application is made, if you're a visa national, you declare it, what you're going to do. I'm going to do this particular permitted paid activity. If you come as an entry clearance, if you're asked at the border by the immigration officer, that is the second part. If you are a non-visa national, say Australian, American, so then you have to declare it at the border that I'm going to do this permitted paid engagement at the point of entry. Evidence by a formal invitation. So whoever is the sponsor over here for whom you're going to deliver that engagement need to have a letter from them, an invitation, and relate to the applicant's area of expertise or occupation, whatever that is. And other permitted activities that have been included, I see them are academic who's highly qualified, so field of expertise, a specific giving lectures in the UK, yeah, in particular different fields, pilot examiner, a qualified lawyer coming for advocacy in the court, and professional artist, entertainer, musician coming to carry out activity directly into the profession. Professional sports person, a speaker coming for one off or a short of series of talks. So these are the only main areas of work which can be done. There is not much of a big change. Yeah, there is not much of a big change that has come into play. I know some of those videos are stating that you can work in the UK, rules have been changed. Yeah, so I just wanted to bust that myth that that is not right. This is the immigration rules in front of you. And yeah, visitors cannot work in the UK overall. That is a summary of this. Thank you very much. If you like this video, do subscribe to our channel, like this video, and if you want to join such lives, become a member. There are membership options where you can ask questions in such lives. So that is the option you have.